Okay, brilliant. I think if you're ready, Helen, then I'll get started, and people can just come in as and when, as
Absolutely.
yeah, great. Thank you. Well, first of all, from me, so my name's Bethany Walker. I'm a private wealth solicitor at Moore Barlow, and I'll be chairing today's session on behalf of Surrey Law Society. So thanks very much and welcome to everyone joining this session hosted by Surrey Law Society. So this is charting the IHT course, strategies for navigating uncertainty and advising clients in the year ahead, obviously, especially with the budget that we've just had. This session was actually postponed because of that. So I'm sure Helen will have some great commentary on that. So yeah, so this session is one of a variety of webinars available that Surrey Law Society actually put on free of charge to its members and over the course of the year. So if you are a member, you'll be receiving the emails anyway, which have not just obviously for private clients, as you can see on the screen now, we've also got a family law update coming up, as well as Surrey Law Society's charity fundraiser at the end of April as well, which I've heard there's some fantastic prizes on, ready to be won there. So definitely get your tickets for that. And as I say, through the emails, you'll be hearing from the Society of all of these sessions that we have coming up. So really great stuff. And you can obviously view the full programme at the Surrey Law Society's website as well. So just a bit of housekeeping. So as I say, thank you very much for joining us. We have the brilliant Helen Foster here, who will be dealing with navigating the uncertainty that's definitely been caused by the budget, but also just in our industry at the moment. So in terms of any questions that you might have throughout the course of this session, please feel free to use the Q&A box, or otherwise ask your questions at the end by raising your hand, and we'll facilitate those as we go through. But really, without further ado, if you're happy, Helen, I'll pass over to you to introduce yourself and get started. Thank you.
Absolutely. Thank you very much, Bethany. Right, ladies and gentlemen, I'm just going to share my screen with you. So hopefully you should be able to see this. A very, very good afternoon to you. Some of you may already know me. Some of you may have seen me lecture before. So I do basically lecture on all things private clients. So I deal with wills, trust, tax planning, corporate protection, all that sort of thing. I own my own law firm for my sins, and we are a team that specialises bespokely in this sort of work. I also train throughout the country, so hence why some of you may well have seen me already. What I tend to do is rant, I think, most of the time, especially when it comes to things like the budget, because this was originally arranged to discuss all the potential changes that were coming in, because they were going to hit the gifting rules for lifetime gifts. They were going to get rid of the £3,000 allowance. They were going to bring in a 5-year, all these sorts of things that they were going to bring in instead of what we've got currently. Some people were actually telling me, oh, we won't have to worry about inheritance tax. It was genuinely a financial advisor who advised a client of mine who had 2.2 million. You won't need to worry about all of this because inheritance tax will be abolished in April. I nearly spat my coffee out. Of course, that didn't happen. And so I could kind of sit here and say, let's take a moment to deal with the changes. There we are, they're done. But the reality of it is that it's not just about the budget. There has been so much change in what we do. I think over the last couple of years in particular, that has a real knock-on effect. Not just about things like electronic wills that are coming in, how we're going to deal with that, but of course, all these rules that came in and the nuances of things like the residence nil rate bans. How do the actual reliefs work? Reliefs that are missed, things that we should be advising clients now, because more clients are now, because of the fact that this allowance has been frozen for so long, clients who ordinarily wouldn't have been in the tax brackets of worrying about inheritance tax are now getting knocked into it. And so there's things that we really need to be advising clients on a more regular basis, things that we genuinely never thought about before. There's also a couple of other things that I really raise here, because whilst we have this scenario, what a lot of people are trying to do is, of course, gift assets away in their lifetime. I've had so many people that say to me, oh, well, I want to make sure that my family's provided for. Can I not give them what I would normally give them on inheritance in their lifetime? Well, potentially you can, but you've got to be careful about things like gifts with reservation of benefit, or indeed pre-owned asset tax, which is the one that worries me most. So right at the end, we're going to talk about that as well. So we will be referencing a lot of these. The only downside to me sharing my screen is I can't see the Q&A box if you are asking me any questions, ladies and gentlemen. So what I'm going to suggest is when we get to the end, of course, and I see that box, I'll be able to answer any questions. In addition, though, if we don't get enough time to answer all your questions, you can email Eloise. I think you've got her details already, and they can then field these to me, so I can answer them after the session as well. So if I go back to basics for a second, the most common thing that I'm now seeing that we need to be getting more in tune with is the use of trusts. I know some of you may not be STEP qualified. That's absolutely fine. But we do tend to see trusts built into wills, and we do see people nowadays trying to utilise them in their lifetime. These people that are saying, well, I want to make sure that my children get some inheritance when I die. I'm concerned about care fees. Now, this is a really important one. I find a lot of people, and I did have a look at and did some window shopping even locally to me. I'm based in Yorkshire, so I'm not Surrey based actually, but when I look locally, there are some firms here that are still advertising that they do care fees planning, and that's a major danger with any of these, because local authorities are now saying if the sole purpose of doing anything is deliberate deprivation of assets for care fees, then we're going to unravel it. So we need to be changing it to asset protection. And a lot of people are saying this, I want to protect my assets for my loved ones. How can I go about it? And so what I wanted to do was just do a very quick kind of review of the more common types of trust that we see, both in someone's lifetime and on death, and how they work for tax, because this makes a massive change and needs to be something that we are telling clients about. All right. Now, I use HMRC's definition of trusts, so I call them bare trusts, life interest trusts, discretionary trusts. Technically, you can call these whatever you want. Doesn't matter. I've heard some hilarious things. I had one elder couple that came to me and they said, oh, yes, we're interested in a sideways disinheritance trust that I saw in the Daily Mail. I was like, okay. And when they described this to me, I was like, oh, so it's a discretionary trust then. Because you can call them whatever you want, and that's fine, but it's how they operate that is important. And so if any of you haven't been on, I would recommend to go on to HMRC's internal manual for inheritance tax. So if you type it in, HMRC Inheritance Tax Manual, bookmark it. It's available for us to look at, and do have a look through it. So a bare trust would be your standard sort of basic form of trust that we see. Sometimes people do call it a simple trust, and it's as easy as it can get. Usually we see these in a will, and it is usually for children who are under the age of 18, minor children. So I've given you an example. Jake leaves his sister Minnie some money in his will. The money is to be held in trust. If there's no age set, that would be the age of 18. That's fine, but it could be 21, 23, 25, couldn't it? Minnie is the beneficiary and is entitled to the money and any income it earns. So it is her assets. She also has a right to take possession of the money at any time, assuming she's over the age of 18. So technically, any money that somebody receives in an estate could be in a bare trust, but you are entitled to it once you hit whatever age of contingency. It's like handing over the bank book, isn't it? It is your asset. So it's most commonly seen on death. I have seen a few of these set up in someone's lifetime, but they tend to be things like personal injury trusts, those sorts of things, and medical negligence. I don't tend to see them set up that often for anyone other than children. Having said that, I would see them in someone's lifetime for things like premium bonds for children, or if granny sets up a NatWest bank account as a trust account for a child, like a grandchild. All right, so you do see them. What is so important about them? Well, it's that person's assets. So if they die, it's their assets. Okay. The other point is trust registration. So this is a new requirement that came in. Any express trust, either in a will or in someone's lifetime, unless you fit within some exemptions, would require to be registered. So you'd always have to check, does this need to be registered on the trust registration service? Now, that's a totally different kettle of fish. We could talk all day about that. So we're not going to go into detail about the TRS today, but it's just food for thought. For a lot of these, they can be exempt, but certainly be aware that you need to check the rules in terms of whether or not they need to be registered. They will work the same in lifetime and on death. Now, if you're going to set one of these up, a life interest trust, these work very differently if you do them in someone's lifetime, or inter-vivos as we call it. So be aware of the difference. So how we tend to see a life interest trust usually is in a will again. You'd have a husband and wife. I regularly kill my husband off. It's probably wishful thinking, but there we go. So I kill him off regularly. I'm going to kill him off now. So the most common thing we see in the will is a spouse dies. Instead of leaving everything to the surviving spouse, what they do is they change the ownership of their property to tenants in common. So my husband owns half the house, I own half the house. When he dies, he leaves it in his will then, instead of it automatically passing to me. And in his will, he says, me as spouse, I can live there for my lifetime. I can downsize, I can use it. After I die, and you can set parameters, I could cohabit, remarry, go into care, whatever it might be. If any of these things happen, then the remainder men, they're called, get what's left. So the other beneficiaries. And it's usually children. Okay, now what that means in terms of inheritance tax, when my husband dies, anything that's left to me, spouse, is tax-free. HMRC will count this trust for tax purposes as though it is mine. So it will be still tax-free, that half a house. It will then be taxed on my death, and provided that it passes to qualifying beneficiaries for the residence nil rate band, and we talk about that later, then I will get 2 allowances, double allowances. So it's exactly the same as my husband leaving everything to me in terms of tax allowances. There is a downside to these, ladies and gentlemen. There's a lot of people aren't getting married anymore. They are cohabiting. And if you cohabit, you do not get these allowances. So imagine my husband and I were cohabiting instead. It really is wishful thinking, isn't it? I've killed him off and now we're not married. But anyway, imagine we were cohabiting instead and he dies and he set up a trust such as this. I've now got a problem because he has left it in a trust for me. It's classified as my asset with HMRC. I get to use it for my lifetime, like I've just said. But I'm not a spouse, so I don't get a tax-free allowance. So it's potentially taxed on his death. Now, what happens is when I die, any assets in this trust that I've been able to use for my lifetime get lumped with my assets. So when I die, I've got all my assets plus this trust that adds to it. But I don't get any transferable allowances because we weren't married. So essentially, we might have a double tax situation when we set these up for anyone who isn't a spouse or civil partner. Be really, really careful about this. I wouldn't say to advise people to get married. I've asked a few, suggested it will be useful for tax purposes, but ultimately you've got to be really, really careful and make sure that you're advising them the right way. I had a couple where somebody had built this into the will and they are cohabiting, and I actually worked the tax out. We're reviewing the will now, thank goodness, and I was working out the tax situation. It was going to cause him a tax liability of 110,000. It was going to cause his cohabitee, if she died second, 60,000 in tax. What I actually did was I passed it into a discretionary trust instead that we're going to talk about later, because his half was actually under that amount, under 325,000. It then wasn't classified as her asset. It meant that his tax had dropped. His tax would be similar, but her tax had dropped. I also have the ability of taking assets out within 2 years to give part of the property to his daughter, which would get him a residence nil rate band. So there's lots of things you can do, and I will talk about that in a little bit more detail later, but it saved a lot of tax. So just be aware there are problems if you set these up for somebody who is not a spouse or civil partner. It gets even worse because some people are doing this in their lifetime. I will guarantee this will happen to you. I had a client that contacted me and they said, I want to set up a trust because Jim down the pub, he's done this and I think it sounds awesome. I'd love to go to this pub where people get all their legal and financial advice. But genuinely people do this, don't they? Oh, I think so-and-so's done it and they say it's great, so I want to do it. And so many people are setting up a trust such as this, a life interest trust, in their lifetime. So they're gifting their house into a trust, but they're going to continue to live there because, and in their words, they say, no, it's my house. And then you've just given it away. It's not your house anymore. Well, no, it is. No, it's not. But anyway, you can have that conversation round and round. But anyway, the point is they say, well, no, I want to gift my house into a trust, and I also want to live there rent-free for my lifetime. Well, that's a have your cake and eat it, isn't it? And in terms of how that works for inheritance tax, I'm sure we're all aware, well, you've made a gift, but you haven't actually totally given it. You haven't made a gift and walked away. It's clearly a gift with reservation of benefits because you're continuing to benefit from the asset. And so for inheritance tax purposes, if anyone was setting these up in their lifetime for this purpose, it's not going to work. If it was a rental property, that might be totally different. You might gift that into a trust. You have some issues with income, but you could gift that away. As long as you're planning to walk away from it, it's keeping it. And the family home is the thing people are doing for the most part because they're saying, well, it could safeguard it for care. Well, yes, but you've got to have other reasons for doing it. If your only reason is care fees, it is going to get unravelled. All right. The other problem you've got is a lot of people are saying, oh, if I do this, it's going to stop any Inheritance Act claims. And I find that quite interesting. So they basically said, if there's a claim on my estate when I die by, I don't know, black sheep of the family, daughter or son or whoever it is, they're estranged. They make a claim on my estate. Well, my estate doesn't own this asset. I've got rid of it. Again, if that's the reason why you've done it, I actually think that can be unravelled as well. I think they can chase into it. So I think there's a bit of a danger doing that. I think there's risks to do it. So you've got to be careful in terms of the reasons why you're doing it. If we're doing it for asset protection because you've got other children. So I'll give an example of one I did. And it was a lady who had inherited from her husband, but it was a second marriage and he had children. So he'd left her everything. And she said, I want to do this. Because if I put this into a trust, then basically it gives them certainty. I can't then change it. So I want a life interest trust instead, which means that they have certainty that they're going to inherit. I'm not then going to marry somebody else and leave it to them or leave it all to my own kids. So that was quite a nice one. You get the idea. I know sometimes that doesn't happen, but you get the idea. That was a completely legitimate reason to do it. And of course, the whole point is, yes, care fees might well be something incidental to it, like a benefit incidental to it, but it can't be the main reason why you're doing it. Okay. The other problem with inter-vivos ones, though, you set this up in your lifetime, not only are you going to have a problem with a gift of reservation of benefit. So for inheritance tax, the whole value of that property is going to be added into your assets as it was before. When it comes to the residence nil rate band, if you have passed your property into a trust, doesn't matter that it passes to kids within the trust, you don't own that property anymore. And unfortunately, the result of that, you will not get the residence nil rate band. So people setting these up in their lifetime to potentially safeguard against care, it may well work for care if you have it and it's been there 10, 15 years. It's going to be very hard for them to say the only reason why you did it was care fees. Absolutely. But the reality of it is you're restricting your estate to a maximum of 2 nil rate bands for a husband and wife. And I think that's a major, major problem. So just be aware of that. Right, discretionary trusts, I think, are the most underused thing that we have. This is the best tool in your arsenal and the thing you need to be using nowadays with clients, whether it's inter-vivos or whether it's on death. And this is where befriending a really good financial advisor comes into. If I could give you any advice, befriend a financial advisor, a barrister, and a good tax advisor, and you'd be all right. You'll be okay. You'll be set. But discretionary trusts essentially can hold pretty much anything. They can't hold an ISA because an ISA is an individual savings account, but it can hold anything else. And the best thing about them is who owns the asset? The trust. So the trustees decide who gets money, when, and how much. That is how it works. Okay, and they will often have a letter of wishes by the person, either the testator if it's in a will, or from the actual person when he was setting it up in someone's lifetime. So you'll have a letter of wishes by the settlor. Okay. Why are they so good? Well, certainly in a will, and I'm going to give an example of a gentleman that I actually did one of these for. You can essentially give him a crystal ball. So my client, he had terminal liver cancer. He cannot be cured, but having said that, the liver does regenerate itself. It has this unique ability, all right? And so we don't know whether he's got 3 years, 10 years, 30 years. He could live till he's in his 80s. It might not kill him, if you know what I mean. Something else could. We do not know how long he's got, but we do know technically he is terminal. He's got 2 young children who are currently under the age of 18. And the issue came, well, we're talking about tax planning, and he needs every penny he can because he has a Ferrari room. It gives you an idea. So he's got a tax problem. But having said that, I talked to him through all of the rules for inheritance tax. And the issue we had came around the residence nil rate band, because he said, look, in order for me to get that allowance, you can't set a contingent age, which means those kids will have to get that house at the age of 18. And he turned around and said, if I died tomorrow, there is no chuffing way I want them to have a house or even £175,000 worth of that house. They're going to blow it. I do not want that. But having said that, I could live 20, 30, 40 years. They could be up, married, and have their own kids. So in that scenario, I'm absolutely fine. But if you build it into the will now and I die tomorrow, I've got a problem with it. So how can we resolve it? Well, that's where, ladies and gentlemen, this discretionary trust is where it's at. Because I said to him, okay, place everything into your discretionary trust then. The downside to that, I've just mentioned to you that if you have an asset in a trust, it doesn't pass to children. If it doesn't pass to children, it passes into a trust. Well, it won't qualify for the residence nil rate band under the current rules. Absolutely. However, the reason why I've done this is I have a period of 2 years when this is in a will to alter the situation. There's something called a readback that acts like a deed of variation. For those of you who are really geeky like me, and I know I need to get out more, I appreciate, sections 142 and 144 of the Inheritance Tax Act is where this has this readback. And essentially, if you take assets out of a discretionary trust within 2 years from the date of death, it's read back into the will of the deceased as though they made that gift, exactly like a deed of variation. And so for this gentleman who said, look, if my kids are in their 30s, married with their own kids, I'm perfectly happy to get the tax allowance. He was worried, if you remember, because they were pre-18, that he doesn't want them to get it at that age. Well, the beauty of this is I can take that property out. Let's say he did die in 20, 30 years' time. The discretionary trust kicks in. I can take the property out and just give it to the kids. By doing that, I will get the residence nil rate band and I can claim that. And if I do it before month 6, which is when inheritance tax is due to be paid after his death, I can submit the papers as though he gave the house to the kids and everything else was in the trust. So I don't even have to pay the tax and claim it back. I can do it all in one. All right. So essentially what I'm doing is saying to my client, I'm technically giving you a tax problem, but I'm actually giving you total flexibility where I can resolve that tax problem based on the circumstances at the time. And not only that, it could be that the rules change. I can make use of the rules in the best way possible when you die by placing them in this trust. And so he loved that. So he said, yeah, put my entire estate in there because it's to 2 young kids. I do not know what the situation's going to be, but what I'll do is I'll keep updating my letter of wishes and the trustees can then action that accordingly. I think that to me is a good way to do this. Similarly, people set these up in their lifetime for tax planning. That's fine, but we're going to talk about gifts and how that works in a moment. So the difference between the two is, of course, this is in a will and we've got the 2-year readback. If you set it up in someone's lifetime, you don't have that. You will potentially be subject to this, what's called the relevant property trust rules. For a discretionary trust, we always look at 10-year charges, anything above your tax allowance, and it potentially is 325,000, but it depends on what you've done. If I made a gift to Eloise of £50,000, it's her lucky day, and then I die, my nil rate band isn't 325, it's 275. So the amount tax-free in the trust is 275. Also, at the 10-year anniversary, it's the nil rate band at the time. So if the nil rate band magically increases to 400,000, I've made the gift to Eloise. Well, I don't have 400,000, I've got 350. So anything you do in that 7-year period will impact it. And the same goes for when you are doing this in someone's lifetime. Any of you that are advising clients, what's your nil rate band? You get first 325,000 tax free. That's a big problem. It's potentially that. But every 10 years, assuming you have got your full nil rate band, your nil rate band's tax-free. Anything above that will be taxed at 6%. That's not as high as it sounds. I worked it out on 350,000, it was £1,500. I think you should be giving that advice to a client in terms of an example like that. Work out the tax on a little bit more. It gives them an idea because it puts it into perspective, because 6% sounds like quite a lot, but actually when you put it into that perspective, they go, oh, actually, that's not bad. But the more you go over it, of course, the bigger the problem. All right. So again, putting this into a will trust, well, we have 2 years to figure it out and make it as tax efficient as possible. If ultimately a client says, I need you to keep it there because I'm worried about my son or daughter getting divorced, or I'm worried about them becoming bankrupt, all this sort of thing, well, you'll keep it where it is, isn't it? So you've got to be really careful. And why I say we should befriend advisors? Well, a financial advisor is key here, because potentially we do have income and capital gains tax charges. A trust like this carries half the allowance for capital gains tax. And I'm sure we're all well aware the rules literally next week, I think it is, are going to be changing. So the next tax year, capital gains tax for an individual is £3,000. That's it. For a trust, we carry half that. So the only capital gains allowance we get is 1,500. It's basically nothing, isn't it? It's pointless. And so this is where having a good financial advisor who can invest things in things like offshore bonds, that sort of thing, is really, really key. So discretionary trusts, I use them a lot to plan for somebody in their lifetime, making sure they're aware of something called the backward shadow we're going to talk about in a second. But also I use them on death as well to give you that total flexibility for your client. I don't just do it on second death as well. I've seen so many people that leave everything to each other and then set the trust up on death too. I think you've got a big problem there. Because if you do that, what's the maximum tax-free amount you can get? 1 nil rate band, because it's the second spouse setting up the trust. If you had it in death 1 and 2, so for argument's sake, let's just say you put the residuary estate for both into a discretionary trust. Who are the potential beneficiaries? Spouse, children, grandchildren, whoever they will be. All right. You do it on death 1 and death 2. Well, you're preserving a nil rate band here and a nil rate band here, so potentially up to 650. Whereas if you set it up on death 2, you're halving that. So again, food for thought in terms of how to deal with these now, because we need all the allowances available to us to try and safeguard clients from being subjected to tax. I've seen some people try and get around things like the trust registration service and the 10-year charges, and I think this is a bit of a problem. So what I've seen, and I've just seen this in the will that I reviewed, is one of these trusts, but it was limited in its time frame. So the length of time a trust should be able to survive now and be in place is 125 years. Unfortunately, you can restrict that. And what some people are doing in a will is saying it can only last for a period of 2 years from the date of death. And that's because of the readback. So basically, you have to close this down at the end of 2 years. And because of that, then it's read back into the will of the deceased as though there was no trust ever in existence. And some people are really smug going, so I don't have to worry about trust registration service. I don't have to worry about relevant property charges. Great. Well, yes, I get that. But I think there's a duty of care issue here. Imagine you had, and I had a client like this. She wanted to see me because she said, I'm having an operation. I think I'm going to die. Ironically, she did. It's a bit weird. But anyway, she said, I've got 2 children. Eldest daughter's already on marriage number 4, and I think there's a divorce in the offing. I therefore want to put my assets into a trust. Now she didn't have a huge sum. We had about 300,000. She put it into a trust. All right, that's fine. She can do that. The reality of that was, like I say, she did die, and the daughter wasn't getting divorced at the time, and she pretty much snubbed mum, going, oh, I'm not going to get divorced. And 3 months later, she was like, oh my God, how did she know? It's funny, isn't it? But anyway, the point that I'm getting at is, imagine you were in that scenario and you had a 2-year discretionary trust, and that divorce was quite acrimonious and took quite a long time. And you get to the end of the year 2, where now you have to distribute the assets. The letter of wishes says, assuming everything's okay, I would ideally want the beneficiaries to inherit equally. She's got 2 children. So now the problem I've got is because the trust has to be wound up, I either have to give it all to the other daughter and just hope that she'll gift something on later, which could have a knock-on effect for her own estate, and you're trusting someone else to gift the money. I'm not convinced that's a good way of doing it. Or you split it 50-50 as per the letter of wishes, but now it's going to go in a divorce, which just immediately negates everything that your client tried to achieve in the first place. So I think there is a danger to this, and I wouldn't recommend limiting your discretionary trust to 2 years. What I would suggest doing, if you really wanted to consider this, is in the letter of wishes put in, if my trustees feel it's appropriate, they could wind it up within 2 years. Otherwise, it continues on if they feel it's in the best interest of the trust. It's that simple, isn't it? Put it in your letter of wishes. But that's what some people are doing. Now, very quickly, income and capital gains tax on trusts. You do need to be aware of this. Bare trusts and life interest trusts work the same way. They're classified as that beneficiary's assets. So in a life interest trust, the person who receives the trust initially is called the life tenant. It's classed as their asset. For bare trust, it's classed as their asset. So they can deal with it, the tax on their own tax returns. And I've given you this, so the SA 100. If you're doing it as the trust one, it'll be an SA 107. All right. So it's classed as theirs. It's pretty straightforward. Okay. When we talk about discretionary trusts, they're called relevant property trusts to give them their official name. These work a little bit differently. Now, there was talk of getting rid of this initial £1,000 standard rate. It hasn't gone yet. All right, because of course they didn't deal with anything in the budget to do with this, but this was one of the things they were planning on getting rid of, but it's not gone yet. So up to the first £1,000 is at what's called the standard rate for trusts. After that, you get a higher rate. And I put them on here. Dividends, 8.75. All other income is 20%. That's on your first 1,000. After that, it cranks right up. 45% for income, and dividends is 39.35. So it's really high rate for income in terms of these trusts, and capital gains tax I've already talked about as half the allowance. We don't get any dividend allowance for a trust, just be aware. So that £2,000 you get as an exemption for an individual, no. All dividends received by a trust are taxable. And again, this is why it's really important for us to have a financial advisor on board, because they can put these in non-income producing assets. They can put them offshore, where we only pay tax when you bring them onshore, and you can claim what's called holdover relief and all sorts of different clever things that they can do. So never, ever set anything up without making sure that you have a financial advisor who can also work with your clients. They may have their own. All right. The other thing, like I say, I wanted to talk about was the things people miss. Gifts out of income. This is a really important one. So there are loads of gifts that still are in play that we can use, including the £3,000 a year allowance, which we thought was going, but it's not. So I've listed these off in your slides, and please look through them. And these are all allowable. They do not impact any annual allowances of your client. There's an interesting one that I wanted to put in this one here, though, which is midway down the page. Payments to help with another person's living costs. That's a really important one. So elderly relatives, if you're paying things like third-party top-up for care, or you're having to assist family members with things like utilities, that isn't a gift. It will be exempt. It's an allowable gift. My mum died just last year, and she was paying for my grandfather's care because he was refusing to. It was just home care 3 times a day, but it cranked up. And he only died 2 years ago. So this was technically a failed pet, but it wasn't, because it came into this exemption. This also works for children under the age of 18, and they've accepted of HMRC. This would be children who are in full-time education. So anybody that is at university, that's fine as well. Somebody did say to me, what about people who have a child that just never leaves? You know, like the child's in their 30s and 40s and still living with mum and dad. No, that doesn't work. That would be technically a sponge, but you get the idea. I use that just as a joking way, but you get the idea. Some people do think that they will still be able to utilize that, but no, not when they are older. It is usually when they're in their educational years. Okay. But these are all things that we have that people know about. Regular gifts of income, people do know about. So things like Christmas and birthday gifts, or if you made a payment to somebody that was just a one-off payment, but you did it every single year, If you have what's called a frequent gift and you can show a pattern, and that pattern is in existence for 3 years or more, HMRC have accepted that that will form part of your normal expenditure. Clearly, you're surviving, and that's fine. So I've seen some people who are making monthly payments to, for example, a grandchild. That's quite common, or a child itself, you know, £200 a month. That technically is a pet and will crank up. It will initially take out your 3,000 a year allowance, but if you're using that already, then technically the £200 a month is a pet, a potentially exempt transfer, for those of you who don't know what I'm talking about. It's not a dog. Now, if though you can show that pattern of 3 years or more where you've been paying that £200 a month, that all drops out because it is a gift out of regular income and it classifies absolutely fine. There is an additional one that you should be thinking about, though, which is this one, Section 21, income gifts, larger lump sums. If it was made out of income and you were perfectly fine, this is an extra one. So surplus income. All right, I'm going to give an example of a client where I had this. So I had a client who, him and his wife, well, they weren't doing very much in 2020 in the COVID years, and they were sat and they reviewed their circumstances and they made a gift to their children of £80,000. Sadly, husband dies suddenly a year later in 2021. So I'm now looking at the situation. The first thing I do is say, well, it was from a joint account. It was husband and wife. So 40,000 was his, 40,000 was hers. Her clock's still running. If she survives it by 7 years, it drops out. His is what's called a failed pet. What can I take off it? I've got annual allowances that I can use, and they'd never done any of the planning. So he can have £3,000 off that for the tax year in which he made it and roll it back 1 year because he never used the year before. So I can take 6,000 off that pet. So the pet isn't 40,000, the pet is 34,000. And that's what most people do, and they leave it at that and declare that to HMRC in his return. So his nil rate band is reduced. But I didn't do that. I said to her, well, what did he do for a living? And she said, oh, well, he was a retired police superintendent. Oh, very handy. His income from his pensions was huge. And of course, for those of you who fondly remember the year 2020, well, nobody could go anywhere or do anything. And so for argument's sake for today, he had a significant sum of income left over that they hadn't spent in that tax year, in addition to his annual allowances. And so I filled in the IHT 403, which is what I'm going to ask you to have a look at. The very back page, it's like a spreadsheet, and it's the last 7 years. And it very simply has income and your share of the expenditure. What's the difference? How much of that was gifted? Now, he didn't think about this when he made the gift, obviously. I'm having to do this at the back end because he's already dead, saying, look, he made a gift of 40,000. 6 of that was in his exemptions. He had significant income, and for the sake of today, I'm going to round it to £14,000 worth of income. So I'm declaring that out of that gift, his surplus income reduces the value of that pet down from 34. I'm going to take 14 off it to 20,000. So the pet is actually 20,000, not 40. And why is that so important? Well, his spouse will get his allowances left over as a percentage. So we're hoping, first of all, she gets past 2028 and the allowances increase eventually. But she's going to need every single penny because she's borderline for tax. If I just left it, that's a heck of a lot more coming out of his nil rate band. And of course, in theory, he has surplus income. We can use that. So I got that approved with HMRC. The result of this is you can do it at the back end like that, but it's actually better if you've got clients that come in to see you and you talk to them about this. So they've got 2 different ways of gifting. They've got regular gifts with that 3 years plus frequency, absolutely fine. You've also got the gifts out of surplus income in any tax year, which you can gift. You're coming up towards the end of the tax year now, so if people do the calculation now, if they've got anything surplus, they could gift that tax-free in addition to all of these other allowances. It doesn't resolve the tax problem if somebody's significantly over for inheritance tax, but it does perhaps cap it. So it's something that I think is really important that is missed. So please be aware of that. There's another one that gets missed a lot. Now, I put this into my lectures because I just assumed everybody knew about this. Exemptions for armed forces. I trained in North Yorkshire by Catterick Garrison, and so this was just something normal for us. But it applies to pretty much gifts made in someone's lifetime and their assets on death. And basically says if somebody was on, it used to be active military service, which was section 154, but they've adapted it as well, and basically said emergency service personnel and policemen. If you are on active service, so if you are on duty and you suffer an injury or wound, here on this slide here, an injury or wound, or you get a disease whilst on active service and you die as a result of it, you don't have to die at the time, you can die years later. But if you die as a result of that injury, then you can apply, or your estate can apply to essentially the Joint Casualty and Compassionate Centre, the Ministry of Defence, basically. The JCCC is where you write to. I've got the details on your slide, on the next slide. But basically, you can apply for a full exemption from inheritance tax. Okay, and this works, like I say, not if you die whilst on duty at that point. It does work for that, but also later on. So, for example, I have a friend of mine who had his leg blown off by an IED in Afghanistan, and he now has a prosthetic leg. And let's say he's absolutely fine, he's married, he's got children, but imagine it's like 2 or 3 decades later and he dies as a complication from something like sepsis as a result of that leg. We'll be able to claim this exemption. Okay, so it's really quite important to know about, and it's not just for armed forces. Like I say, it extends to policemen, firemen, ambulance, but you've got to have suffered the injury or disease whilst on duty. Okay, so there was a horrible case of a paramedic who's seen an accident on the motorway. He got out to help and a lorry plowed into them and killed them. He wasn't on duty. Didn't happen, didn't qualify, which just really suck, doesn't it? But that's you've got to be careful that you qualify for it, and you've got to have the medical evidence to support it. And what do? Well, you don't write to HMRC for it, you write to this Joint Casualty and Compassionate Centre. You can write to the Ministry of Defence, but they will just send it through to this JCCC, so please make sure you write to the same place. Now what happens here, they won't essentially send you a certificate. They used to. So when I used to do this as a trainee, they get you a certificate. You'd get the certificate confirming, yes, we're happy that the full exemption applies under the relevant section from the Inheritance Act, section 154. I would then send my inheritance tax papers to HMRC with that certificate. Bang, done, no tax to pay. What they do now is they'll write you a letter saying, we've told HMRC that the exemption applies to your case. Now you can submit your papers. I think that's a big problem because they're sending that to HMRC and you haven't yet sent your papers to HMRC. So they've got nothing to link it to. But that's what they're doing at the moment. I really hope they go back on that. It has been raised as an issue. But they tend to do this with the probate registry now, don't they? With the probate summary forms and things like that. I mean, that's changed again, just for those of you who don't do this very often. You've now got to send all your papers to HMRC before you make a probate application. They will stamp them. They will then return a letter to you confirming the values and giving you some 16-digit code that you then have to put into your online probate application form. So they've changed the processes again for this. But that's essentially what's going to happen here, I guess, is you'll have to write off to the JCCC. They confirm the certificate has been sent to HMRC. Then you send your papers to HMRC. Then you wait for your code. Then you apply for probate. That's what I think is going to happen with these. Okay. Just be aware that, again, they will essentially not contact you per se. You'll just get a confirmation letter to say, yes, the limits have been met, the exemption's been met in full. We've let HMRC know. So just be aware and tell your clients about that. Right. I'm going to talk about pets and chargeable lifetime transfers now. Successful pets, potentially exempt transfers. I think we all get this, but people are applying the rules incorrectly. As our clients, you need to make sure that they are aware. Here's a simple example. Jemima makes the following transfer. She gives 170,000 to Paddington, and then a year later, 170,000 to Mrs. Tiggy Winkle before she dies. She dies some 2 years later. Her estate is worth £225,000. How does the allowance work? Well, firstly of all, pets can only use a nil rate band or transferable nil rate bands. So you might have double allowances, depends on whether or not, my husband's dead or not, for example. But assuming I've only got the one allowance, firstly of all, how does this work? Well, Paddington's was the earliest failed gift. That will eat into the allowance first. The remaining allowance, 155,000, then gets offset against Mrs. Tiggywinkle's gift. Unfortunately, this means we've got £15,000 worth of allowances of tax due. The 15,000 is a failed pet and will be taxed at 40%. It is only at this point, when you've got an excess that becomes taxable, that you can even consider taper relief. And this is where I'm seeing the problem. The amount of people that say, oh, I can apply taper to that because it was 3 years ago and more, I can taper that gift down. Well, you can only taper a gift if you actually have a part of it that is taxable. If the only gift we had was 170,000 to Paddington, you can't taper that down because it was in excess of 3 years ago. Taper doesn't apply. All right. I had a client who said to me, well, I made a gift 6 years ago of £50,000. So that's great. Even if I die, there's not going to be hardly any tax payable on that. I said, no, that's not how it works. It's just your nil rate band is down by 50,000 until next year. He was absolutely shocked. So make sure you're informing clients of that. But they get even worse when people are doing this lifetime planning that I spoke to you about. And this is this backward shadow that I was saying about. And that's because when people are setting up a trust, you can put money into a trust. You can put 325,000 in as your lifetime rate into trust, assuming you've made no other gifts. That's fine. But you've got to be aware of how they work. And that's because of something called the backward shadow. It's easier for me to give you an example. Thor, he makes the following transfers before he dies in September 2011. He gives £50,000 to Hawkeye in January 2002, and then 60,000 a month later into a discretionary trust. 4 years later, 75,000 is gifted to Black Widow outright, and then 3 years after that, 200,000 to Iron Man. So what do people do? Well, the first thing you do is you say, right, Thor's died in September 2011. I'm only bothered about what happens in the last 7 years, which is September 2004. And so Hawkeye and the discretionary trust drop out. Black Widow's gift eats into the allowance first, then Iron Man's. I'm left with £50,000 worth of Thor's allowance for his estate. That's what a lot of people do. If you do that, ladies and gentlemen, you are negligent. That is not how it works. Basically, you are correct. Any specific gift, a pet that is outside of the 7 years, is a successful pet and it's omitted. It's taken out of the calculation. So the gift to Hawkeye drops out. That's absolutely fine. But the problem you've got is the discretionary trust isn't a pet. It's a chargeable lifetime transfer. And if we have a failed pet in the 7 years before death, and we do here, we have two, don't we? Black Widow and Iron Man. What you actually have to do is go back to the earliest of those, which is Black Widow in April 2006. And you have to look at what happened in the 7 years before that gift. If there is a trust, it gets caught in. And that's what the backward shadow is. And so essentially what we've got, and I'll go to the next page, if you look midway down here, because of the 7-year rule from the failed pet, this backward shadow, well, the trust's caught in. It eats into the allowance first, then Black Widows, and then Iron Man's. It means that we're 10,000 over. We might potentially have taper relief, but Iron Man's was within 3 years of death, which means no taper applies. Iron Man will have to pay that £4,000. So that's how it works. There's no nil rate band available for Thor's own estate, which doesn't happen. Okay. Now, how do you therefore advise clients who are trying to do all this lifetime planning to safeguard about inheritance tax? Well, I accidentally said this once and it tends to have stuck. The no heavy petting rule is basically what I said. But essentially, you can make as many pets as you want here. You can set your trust up with 325,000. Do that. Make no other pets for 7 years, apart from outside, the allowances, surplus income, all of those normal allowances, all the ones we've talked about. Do those. No other pets. After 7 years, you can pet away. Make as many pets as you want. So no heavy petting in the 7 years from setting up a trust. That will then stop the backward shadow ever kicking in. The danger is people make these gifts because they don't know about that, and we're catching that trust in longer. I hope that makes sense. Just be aware that the taper does not apply. I'm not going to run through taper today, only because I'm conscious about time. I am going to run through this though. Who pays the tax on these? Because this is a scary point if you actually read the legislation. Who pays the tax on a failed gift? The person who received the gift, the legatee. All right, that is the person who should pay the tax. They should fill in an IHT 100 when someone dies, going, yes, I got that gift. Nobody ever does, but they should. The IHT 400 has a bit for their name and address, and they will contact them. The scary bit is this: if somebody isn't resident in the UK and you make a gift to them and then you die, and when it comes to the administration, we have all established, whilst it will reduce the nil rate band, the estate doesn't pay the tax, the legatee pays it. But we can't find them. They're not resident in the UK. We cannot find them. The legislation indicates that HMRC can chase the executors for that. I think that's quite scary. So a personal liability. I know a lot of you may well act as professional executors. And on the face of it, this is a pretty scary thing. However, there's a quotation in the Gazette where this was raised, and it is accepted with HMRC as long as you have done everything you can to try and locate that legatee. So you'll have to get a genealogist in, try and locate them. You have told HMRC either the gift has been made or you've declared it as soon as you found it, because there have been cases where it hasn't come to light until after you've administered an estate. This is a major problem. If you're not getting bank statements going back 7 years, then you can be in problems with this, because you should have done your duty, your client care, and obtaining 7 years worth of bank statements really for looking back 7 years is what you should be doing. Never trust a client. If you ask the executor, did a deceased parent make any gifts? No. I had a client that did this, got hold of the bank statements. I said, but Mr. Smith, you received 200,000 5 years ago, and your dad's estate is 1.5 million. This has a massive impact. He goes, oh, I hoped you wouldn't find it. What? You know, they do searches. They are clamping down a lot more on this now. So get hold of 7 years worth of bank statements. Provided you've done that, you couldn't have found it because a gift was made from a closed bank account, for example. That has happened in the past. It comes to light later after you've administered the estate. Well, as long as you had made all these checks and you did everything you could, and there was no possible way you could have found that gift, or you knew the gift had been made, but there's no possible way you could find them, you've done everything you can, HMRC have said they will not chase the executors. So this is really the impact that you've now got when you're administering estates, ladies and gentlemen. You need to be advising executors to carry out asset searches, will searches, genealogist searches, those sorts of things. If you're not doing that, we could have problems with these. Okay, always obtain those 7 years worth of bank statements and check them to see what has happened. Final things I want to talk to you about is to give a reservation of benefit and pre-owned asset tax that I talked to you about before, because like I say, a lot of people are trying to do this planning. They've done it because of Jim down the pub, and a lot of them think, well, I don't need to pay a solicitor or practitioner for this, do I? Of course not, because you can just do it yourself, because why bother having these specialists who's taken years of exams for this? Of course, they can just do it themselves because they know everything. And they're causing themselves major problems because of these pieces of legislation. Most of us know about gift of reservation of benefit. The problem I'm seeing mostly here is people gifting away holiday homes. So gift reservation are you make a gift, but you don't give bona fide possession, actual possession of it. So the obvious one would be gifting your family home away and continuing to live there rent free, like I mentioned earlier. But like I say, the family home is one thing, a holiday home is another. If you gift away a holiday home to children, and a lot of people are doing this, but you continue to visit it for holidays, basically, if you're going to spend more than 2 weeks in a year there, HMRC will say that's a gift for reservation. They do accept that 2 weeks is an exclusion, is virtually to the entire exclusion, and will come under the exemption here, where you can be virtually to the entire exclusion. So that's quite useful. But if it's more than 2 weeks, you're going to fall foul of it. So just be aware of that. Okay, the one that people aren't that aware of is pre-owned asset tax. And I see this so much more now. So I had a client where it was a mum and daughter needed some money to get on the property ladder, basically, and mum decided to help her out, which is what happens a lot nowadays. So her mum gave her £80,000 and she put that into a house. That's fine. It's a cash gift, isn't it? So that's a pet. We can all agree that's fine. All right. And then what happened? Well, 5 years later, mum needs care. Daughter says, you're not going into a care home, you're going to come and live with me. And so mum moved in with daughter. And from the moment she moved in, she is now benefiting from an asset, the cash that was used to buy that house. How did I find out? Well, I asked what happened when mum, I was dealing with mum's estate, and I asked daughter, I said, where was she living when she died? Oh, she was living with me. And I said, well, did she ever put anything into this? Oh, well, yes. And that's where this came out. There is an exemption. If she'd put the cash in and it was over 7 years before she had benefited, it would have been fine, but it was within 5 years. Now, pre-owned asset tax is not a tax like a gift for reservation of benefit. Gift for reservation of benefit, essentially, when you die, that asset's still classed as yours. Well, pre-owned asset tax isn't. You are paying an annual amount on a tax return, and it's basically the rental value of the asset you're benefiting from. So in this case with the mother and daughter, mum owned, let's just say for argument's sake, a quarter of the property. So what we should have done was worked out what the rental value of that house was for each year, and she would be her tax would be 25% of that, a quarter of it, because she owned a quarter of the house technically. All right, that's what we should have paid on her tax return every year for the tax years in which she resided there before her death. That was 3 tax years. She hadn't done that because she didn't know. She didn't fill in a tax return. The result of that, I had to then deal with it when she died. I got slammed with late filing penalties and interest. I managed to get the penalties waived, but the amount of tax she had to pay with interest, I couldn't. All right, so that's how pre-owned asset tax applies. There are 2 conditions to hit it. The first one is you gift an asset away totally and then later benefit from it. So it can never be a gift of reservation. So I've given an example at the bottom. Bob, he gives 4 Winds to Greg. He walks away from it, 4 Winds being a house. All right, so Bob makes a bona fide, genuine gift. 7-year rule applies, doesn't it? Greg then sells 4 Winds and buys West Point with the proceeds, and then Bob occupies West Point. So he moves into it and goes, well, I've never owned it. Well, your proceeds were used to buy it. That would hit the condition. And that's what it was designed to thwart, was people who were doing this, you know, trying to get around the system to safeguard against inheritance tax. Then you've got the contribution condition, which is what my client inadvertently fell foul of, not because she was trying to avoid tax, because she didn't know about it. All right, when you contribute towards something that you later benefit from. So there are your 2 conditions. Now, if I'd known about this, if a client had said this to you and alarm bells are ringing, well, what can they do? If this lady had come to see me and said, well, I'm moving in with my daughter, and I ascertained she'd put this 80,000 in, what could I do? Well, in the tax year in which the first charge is due, and of course, as we know, when we fill in tax returns, we tend to have until the 31st of January the next year, don't we, for tax returns? She could elect to change it to a gift for reservation of benefit instead, using an IHT 500. I bet you didn't even know they go that high. It's an IHT 500, all right? And if she'd elected to that, and this is what I would have done, well, 25% of the house is classed as hers, and when she dies, whatever that value is gets added. She had allowances because she was a widow. She had double allowances, so actually it would have been tax-free. Otherwise, I could have said, stay where you are. And after 2 years, because I said she'd survived by 5 years, she went in after 5 years into her daughter's house. If she'd gone in after 7, then it would have been fine as well. She wouldn't have been subject to the tax, because if it's a cash gift, there is an exemption. If you benefit from the asset that was used to purchase, it was purchased from that, 7 years after, it's exempt too. So she had 2 ways of being exempt, either that or electing. Unfortunately, a personal representative cannot elect. So it's horse and stable door. She was already dead. If she'd known about this in a lifetime, that's what we could have done. And most people will elect because they'll have the allowances available. If they don't, the asset's not classed as theirs. That's fine. It means that they won't have any inheritance tax to pay, but you're going to have to stump up this tax every single year. Okay, now a lot of people are falling foul of this without even realizing, and this is why I raise it, because you will have a lot of people that have tried to do planning or help out family members, and this is where we're having the problem. Okay, so just be aware of that. Okay, for the calculation, please do look through this slide and have a look, but basically it's the market value, and I've put the exemptions there, but I am conscious we're at 1:30. Doesn't time fly when you're having so much fun? So please do have a look at these. I'm going to end the slideshow here. So I'm going to stop sharing here so I can see any questions you may have. But really, it's a bit of a whistle-stop tour today in terms of all the things that we never thought of and never thought we needed. I think years ago when I first started, none of this, I mean, pre-owned asset tax, what was that? Whereas now these are just becoming more and more prevalent. So I hope you found that useful, ladies and gentlemen. I'll just quickly go into the Q&A and see if there's anything in there. But what I would say is if you do have any questions, feel free to email Bethany, Eloise. They can get them to me. But I'll let Bethany kick in now. You'll need to unmute your mic, Bethany, just to let you know. But it's been a pleasure speaking to you all today. Thank you very much for listening to me.
Brilliant. Thank you so much, Helen. And as ever, it's always a worry when you come to these sessions. You think, please don't say something that I haven't considered. But thank you so much. Really, really
You're
clear,
welcome.
really helpful, and very, very current, as you say. So thank you so much. And I hope everyone's found that really useful, which I'm sure they have. And as I say, as Helen says, any questions, just direct them our way and we'll get them answered for you. So yeah, unless there are any questions, thanks very much, everyone, and enjoy the rest of your day. Thank
And
you.
thank you very much, everyone. I hope I haven't freaked you out too much, but I always say a good course is one that at least freaks you out at least twice. So if you
Yeah.
are freaked out about anything or want me to clarify, please do. I think the slides will be circulated, so you'll have those. But if there is anything that has bothered you, please feel free to come to me. Otherwise, it's been a pleasure, and I'll leave you to the rest of your day.
Brilliant. Thanks so much, Helen. Thanks,
Thank you.
everyone. Take care. Bye. Bye.
Thanks.